it was ruled by the Bombay High Court in Leica Labs versus State of Maharashtra that the signatory of a check authorized by the company is not the drawer under Section 143A of the Negotiable Instruments Act and therefore cannot be ordered to pay interim compensation. The question is whether the signatory to a check authorized by the company is a drawer and whether such a signatory could be directed to pay interim compensation in terms of Section 143A of the Negotiable Instruments Act 1881, removing the company from the action, that is to say, leaving the company aside in terms of the action, and whether a deposit of 20% of the fine or compensation is required under Section 148 of the NI Act in an appeal filed by a person other than a drawer against the conviction and sentence under Section 138. The Bombay High Court has adjudicated the case of Leica Labs Limited versus State of Maharashtra by taking into account two leading Supreme Court precedents. They are 1. Anita Hada case, that is to say, the Supreme Court had to determine whether it was permissible to maintain a complaint against a director or authorized signatory of a company without joining the company as a defendant. The Supreme Court's stated answer is in the negative, as the provisions of Section 141 NI Act require the company to have committed the offence before it would be liable for the liability of another. It is observed that the words as well as the company appearing in the sections make it unmistakably clear that when the company can be prosecuted, only those persons mentioned in the other categories could be vicariously liable for the offence subject to the averments in the petition and proof thereof. Consequently, the company can be prosecuted as an accused only if it is named as a defendant in the complaint under Section 138 of the NI Act. It has been determined that the company was a principal offender in a prosecution under Section 138 and an authorized signatory is vicariously liable under Section 141(2). Whereas in a subsequent case, which is the case of N. Harihara, the apex court considered that where the appellant signed a check in his capacity as a company director or as an authorized signatory, in such scenarios, he is only vicariously liable for the offence committed by the company. According to the judgment in Anita Hada, prosecution against an individual would not be successful without prosecuting the company as well. In accordance with the Supreme Court, the check drawer is the only person capable of committing the offence under Section 138. An individual who signs a check on behalf of a company does not become a drawer of the check. A person duly authorized to sign the check on behalf of the company or drawer of the check is such a signatory. It is obvious from the Hariharan judgment that the apex court, observing and relying on Anita Hada, has held that every person signing a check on behalf of the company on whose account the check is drawn does not become the drawer of the check, but is simply a signatory who is duly authorized to sign the check on behalf of the company or the drawer. Following Anita Hada, the apex court made these observations, which are binding, of course, on all the courts in India. It is therefore not permissible to include an authorized signatory within the expression of drawer under sections 143A and 148 of the Negotiable Instruments Act 1881. Accordingly, amended section 148 needs to be interpreted to exclude an authorized signatory from the term drawer in section 143A. According to section 148, the appellate court is given the power to direct in terms of a deposit of at least 20% of the fine or compensation awarded by the trial court in an appeal by the drawer. According to Section 148, this power can only be exercised by the drawer in an appeal. Section 148 should be interpreted to mean that such authority to direct compensation is conferred on the appellate court only when the drawer appeals against the conviction under Section 138 of the Act. As already mentioned in the earlier part of our discussion, drawer does not include a director or any authorized signatory of a company. The proviso to Section 148 clarifies that such payment shall be in addition to the amount payable under Section 143A. A drawer under Section 143A does not include an authorized signatory of a company. Therefore, the language of the proviso to Section 148 supports the interpretation that such power only applies to appeals filed by drawers. In addition, Section 148 begins with the notwithstanding clause, having an overriding effect on the 1973 Code of Criminal Procedure. The appeal court, on the other hand, has the power under Section 389 of the Code of Criminal Procedure Act to direct depositing of an amount in an appeal under Section 148 of the NI Act filed by any person other than the drawer against a conviction under Section 138. While considering an application for suspension of conviction or sentence filed by a person other than the drawer. The conclusion is that the signatory of the check authorized by the company is not the drawer under the Section 143A of the NI Act and cannot be ordered to pay interim compensation. The deposit of 20% of the fine or compensation is not required in an appeal filed under Section 148 of the NI Act by someone other than the drawer against the conviction under Section 138. However, the appellate court has been given the power to direct to deposit compensation in appeal filed by parties other than the drawer against the conviction under Section 138 of the NI Act while suspending sentence under Section 389. The ultimate responsibility of the check bouncing lies on the company, and a signatory or a director who happens to be a signatory are vicariously liable, but they are not liable directly. But even to trigger their vicarious liability, the company needs to be arraigned in any check bouncing case as the principal defendant, followed by any directors. But the directors or authorized signatories need not pay any interim compensation pending the trial. That's what is a great relief to many companies, authorized signatories who get harassed in check bouncing cases. Hope the information is useful to you. Thank you very much.